Hi, my name is Rebecca Carlene, and we're going to be talking tort law with case examples in the educational setting. Our first case we're going to talk about is Mitchell versus Cedar Rapids. This was a negligence and breach of duty law with unintentional tort. It happened in June of 2013. A student left school property and a parent wasn't properly informed. The thing with this particular case was it was a special education student who skipped their last period or last class, and during this time was initially raped. And so it is school policy that parents receive a phone message, but it's automated, and this parent didn't get that phone message. So if this would have happened in our school, I think it would be handled, very seriously. We had a similar case. With us being a university, I don't know that we would have something, in this context, but we've had something similar where some students in a club went on a field trip. A student didn't care for a facility that they ended up at, didn't think it was educational or pertained to the trip, and so the school then put in a new policy with student travel forms to eliminate that to occur again. I think a proactive measure to prevent something like this happening, maybe making sure that the teachers know that working with special education students, they need to go beyond the school policy, that they've got that duty to ensure that these students are safe. So maybe making special policy for certain circumstances, such as special education students, and maybe how to set a professional ethics that would be beneficial in regards to tort liability. Maybe in this case, if the instructor would have followed not necessarily the school policy, but maybe her process and procedure that she typically does. She mentioned in the report that she does typically follow through with the students' peers, other students, as well as faculty, to find the student, to understand where she's at, and then reach out to the parent personally. Of course, in this instance, she didn't follow her procedure, and so therefore the parent wasn't informed. And so, and maybe even camera footage, as well as extra security between classes, would be beneficial and would have eliminated this particular tort. The next case is Batter versus State of Kansas. This was a trespassing, which is an intentional tort. This happened in August of 1998. A community member was using university property without consent. And so with this case, this particular person was warned prior to the arrest of the criminal trespassing charge. The citizen was found multiple times using different facilities and property of the state of Kansas University. So the citizen was found in the Union watching TV, was given a written warning. The citizen was then found sleeping on a sofa on campus grounds, again given a warning, and a notification that the next time he was found on campus, that the law enforcement would be called. So then again was found using a computer lab within a campus building, which brought on these particular charges. I think if this would to happen in our school, it would be held very similarly. I think our university police would have acted in the same manner of providing a written warning, and then with reoccurring offenses or violations, they would have let the authorized personnel know, law enforcement to then handle after that. A protective measure to prevent tort like this happening again, maybe placing signs around the areas that do need permission to be used, so that there is no misunderstanding on who cannot use that particular area. All right, our next case is Student versus Russo. This was a battery charge with intentional tort. It occurred this February 2018. A teacher initially grabbed the student who was acting suspicious and wasn't responding to his requests. So with this particular case, there was a recent school shooting at this school, and so all the teachers and faculty were on guard as it was, and there was a law policy, I guess would be a better word, that students were not to wear hoodies anymore. And so this particular student was at a school function wearing his hood on his hoodie up to where his face was not seen. So the faculty member who had been there for 21 years and highly ranked in his peers and his teaching, went ahead and approached the student, asking him to take his hood down, to stop and turn around and talk to him. The student was not responding to him, so he grabbed the student, afraid that he was going to be doing something to harm others. The student, of course, fought back, and this is actually still in the process of being charged and going through the court system. So I'm not sure how it's going to end up, but if something like this were to happen at our school, I think our school would have handled it the same way. Physical touching and handling of a student is unacceptable unless they are in obvious danger. A proactive measure to prevent a tort like this happening, maybe just not allowing the student to even be on school property wearing a hoodie or a large coat in that matter. They put a policy in place that students weren't to be wearing hoodies, but obviously that student wasn't following policy and was still at a school event and on school grounds wearing the hoodie. So maybe eliminating the chance for the student to even come onto school property with a hoodie on would have eliminated this occurrence. Describe a set of professional ethics that would benefit in regards to tort liability. Maybe just making sure that all the faculty members know the process of what to do and how to handle a situation like this. Maybe contacting the authorized personnel or law enforcement instead of taking it into his own measures would have eliminated this tort. The next case is going to be Morgan versus Town of Lexington. This was an emotional distress charge with intentional tort. Happened in October of 2011, and it was bullying occurring after school after a student reported physical assault. So with this case, a student was going through a club initiation, and a physical incident occurred, but was later looked into, and the principal noted that it was initially agreed on. He wanted to be a part of the club. This is what they were going to do, and he went through with it. So the first report of physical assault was dropped. But after that, since the student had reported it, he was then bullied. So he was bullied after reporting the physical assault. The student didn't feel safe at school, also didn't feel safe reporting the current, now new bullying because of what happened when he previously reported. The parent tried to report it itself, and administration stated that nothing could occur, no investigation could happen without the student's report. So if this would happen in our school, I feel like maybe our school would have handled it a little more seriously. Bullying is such a hot topic right now. It's really more of a no tolerance policy. So I think they would have maybe reached out to the student if they knew this was happening, but the student was scared to approach them. And so I feel like a lot of our faculty know our advisees and would take that very seriously and reach out to the student to help. A proactive measure to prevent something like this to happen, maybe ensuring that you know what club initiations are really taking place. There should be policy to eliminate any kind of physical assault when doing club initiations. Hazing and that sort of thing should not be happening. So that would have probably eliminated the first reporting, which would have eliminated the possible bullying. On a set of professional ethics that would have benefited in regards to tort liability in this case, the administration and faculty need to understand that it's their position to keep students safe. And so if they would have looked more into the bullying after they had heard from the parent that this was happening, instead of being hesitant and forcing the student to come and report it, maybe would have eliminated this particular case. Our last case is going to be State versus King Island High School students. This involved an assault and false imprisonment with intentional tort. In April 2018, there was hazing of a lacrosse team involved holding players down and exposing their private parts. So the case was, it was videoed and captured with sparking a criminal investigation. 5 players off the lacrosse team had held down players and then pulled their pants down and put their genitals in these other players' faces. So 5 players are being charged at this case, or at this time, in cases still open. If this were to happen at our school, the students would be held to a suspension or expulsion. We actually have a no hazing policy. It is not tolerated. So all that, and that goes towards all students, clubs, and organizations. So we have a particular policy against the hazing for cases like this. A proactive measure to prevent tort like this happening, maybe making sure that the student organization's advisor or faculty member is with students at all time and understand what particular things are going on with that organization and those students. That may have eliminated this possibility to happen. Describing a set of professional ethics that would benefit regarding tort liability. Maybe making sure that the students go through some kind of training and policy understanding that that hazing isn't allowed, and it's a very serious violation, and making sure that we've got a faculty member with our students, making sure that we're keeping them safe. So I thought all 5 of these cases were very interesting. I liked that they ranged. There was a large range with the dates that they occurred. It's kind of sad that we're still having, the hazing and the bullying still going on. But I think schools are being very proactive in trying to eliminate this entirely. So thank you very much.